Hello and welcome to our April 2018 Expertise in Business webinar series. I'm Eric Hobbs, President of Technology Associates, and I'll be your moderator for today. And we are delighted to once again be joined by Mimi Sewell from Sewell Employment Law, located right here in Raleigh. Mimi's firm works with companies across North Carolina with 100 employees or less to provide employment law and human resources compliance advice, prepare employment-related contracts, and defend employers against employment-related claims. So first, real quick, just some housekeeping. If you have questions, please enter them into the chat box or the questions box, and I will get them in front of Mimi. And the other thing, our next webinar is going to be on Tuesday, May the 15th. And in this webinar, we're going to have Stuart Powell from IIANC to discuss the fundamentals of cybersecurity coverage and risks. So if you want to, go to technologyassociates.net/registration for more info on that webinar. So let's get it kicked off. So questions that we're going to tackle today. First, how should terminations be communicated to employees? We'll touch on how employers handle layoffs and position eliminations. What should be communicated in an exit interview, which is super important. What do you do if an employee doesn't show up for work? We've had that happen ourselves, and that's always a vague question, and Mimi answers the questions on that. And how should final payments be submitted following termination? And finally, is severance pay legally required? Which was something that I learned a ton on. So without further ado, I will turn it over to Mimi.
Hi, everyone. Eric, thanks so much for having me again. It's really been a pleasure to do this series with you guys. I want to start with a basic concept of employment law in North Carolina. It's employment at will, and it's the common standard in every state in the United States, really. And I wanted to explain essentially what it means and how it plays into how we go about communicating discipline and making termination decisions, and why it's so important that you hear HR folks and employment attorneys like myself scream at you about documentation. But the reason I want to start here is I get a lot of questions on the concept of right to work and at will. And I want to clarify what those two things mean. So often I hear we're a right to work state, so we don't need to document termination. We'll just terminate anytime we want to. And the first thing I want to clarify is right to work really has nothing to do with that concept. The concept of right to work generally applies to whether or not you have to be forced as an employee to join a union. So what I think most folks are referring to is really this concept of at will. So at will employment is, I'm sure I'm repeating things you all have heard before. The concept means that the employer doesn't have to hire or promise employment for any specified period of time and does not have to provide any reason for termination or any notice before termination. On the flip side, the employee has the same right. So the employee, when you hire them, doesn't have to make any promise of any period of employment that they're going to work for you. And if they want to resign, they don't have to have a specific reason and don't have to provide you with any specific notice. The one caveat here that's very important is that from the employer standpoint, it is true you can terminate for any reason or no reason. However, you cannot terminate for an unlawful reason. And this is where our documentation becomes very important. So the reason here that that's important is the burden of proof to prove that you have not terminated for an unlawful reason is always on the employer. So if you have no documentation of the business reason that you actually terminated an employee or took a significant disciplinary action, if you have no documentation of that business reason, then you have no proof that you haven't terminated for an unlawful reason. So that's the reason, or this at-will concept often gets a lot of employers in trouble because they don't think they need any documentation. From a legal defense standpoint, we always want to have documentation of why we're terminating. Eric, we move to the next slide.
So one thing I'd written a note when we went through the practice on this, and I think I put it in terms that I really understand. And so for me, it's I can let somebody go for no reason, but I just can't let them go for the wrong reason. And retaliation, you've mentioned that, and that's, I think, as a small business owner, kind of our biggest fear. But what you said, and I think it kind of deserves repeating. It really goes back to that proper documentation around performance and not letting things slide. So as an example, and we've had this, somebody shows up late a couple of times, or maybe excessively. You don't document it, but eventually you get fed up and fire them. So it's fired for maybe a good reason, but because I don't have that documentation, it sounds like I'm leaving myself open to some liability there.
Unfortunately, you're right. You're absolutely right. So the key thing to remember is it's the perception of the employee. So if that particular employee that you're letting go happens to fall within a protected status, and you let them go without any real discipline for the reason that you're letting them go, then often the employee perceives it as an improper reason for termination or unlawful reason for termination. And so you're right, without that documentation of those continual attendance violations, it does kind of unnecessarily expose you to some liability risk. You're absolutely right. All right, so let's talk briefly about what effective documentation is. And I know you guys have probably heard some of these things before, so I want to drill them a little bit. So when I talk about effective documentation, I'm talking about a piece of paper that a business or employer could use as a legal defense to an employee's claim. So what I want to see as your attorney is I want to see that you have a consistent practice of documenting all performance and conduct discussions, just to Eric's point here. Even if that's just a verbal and it's a non-formal verbal counseling. So you've got, what I mean by that is you've got an employee that walks in late, in Eric's example, walks in late to work 5-10 minutes. It's not a huge issue maybe, but it's something that you might walk by the employee's cubicle or their office and just say, hey, you were late this morning. You need to be on time. You're supposed to be here at 8:30. That's a verbal counseling. It's not formal. It's not a sit-down reprimand, but you need a consistent practice of at least going back and somehow documenting that you had that conversation. It could be as simple as sending the employee an email to document that as a follow-up later in the day. It could be your practice of simply making a note on a standard form that you keep on your computer or print it out in your office, and you save that form in the employee's handbook, in the employee's personnel file, excuse me. So we want to see some consistent practice. We also want to see that you are, when you do have a more formal disciplinary session with an employee, we want to see that on that actual documentation of that discussion with that employee, that you have signed it as a member of management, that the document is dated, that we can read everyone's signature. So maybe have a line for a signature and a line for a printed name. We also want to see that the employee has been given an opportunity to sign and date the form as well. So the one question I get often is, what do you do if that employee refuses to sign? And let's be honest, that happens quite a bit. When you're disciplining an employee, they're not the happiest, and sometimes they don't like what they're being told. So if you have that scenario where an employee refuses to sign, in order to continue to show a consistent practice and have an effective legal defense document, where the line is for the employee to sign the document, you as the manager need to write on that line, employee refused to sign, and initial it and date your initials. So that now we have a complete record of that discussion with the employee. The other piece or question I often get is, do I have to provide the employee with a copy? Generally speaking, the answer is no. In North Carolina, all employment records that you would place in an employee's file, like a disciplinary record, all of those belong to the employer in North Carolina. So you as the employer do not have to provide an employee with any copies of documents that go in their employee personnel file. Now, most employers have a policy in their handbook that might indicate that you allow the employee to review what's in their personnel file. Some of you may have policies that indicate that employees can make photocopies or request copies of everything in their personnel file. That is perfectly fine. That is up to you. That's part of a culture that you might be trying to grow in your office. If you have a policy like that in place, I would recommend that you follow that policy. But generally speaking, you are not required to give employees copies. And then last key thing, as an attorney, if you contacted me because you had a potential claim, the easiest thing to do to help me defend you quickly and efficiently is to have all of those disciplinary documents in one file. So I recommend having all employee documentation of employee discipline in the employee's personnel file. That includes any documentation that even the employee hasn't seen, perhaps your documentation of a verbal counseling. Often you'll see that some managers keep their own separate files, and that's fine, but at some point we want all of those managers' files to be placed in one employee personnel file maintained with either the HR manager or the individual in your office, business manager perhaps, or even a CFO that manages all of your HR matters. Eric, will you move us?
Yeah, and that's tough as a small business. And I think one thing that you mentioned here is that that verbal counseling for maybe smaller infractions doesn't need to necessarily be a formal form signed by the employee, but just noted that you talked to them. And I think as a small business, that is maybe a little easier to keep up with because you don't want to feel like you're nitpicking your folks. But if you ignore those little things and you don't do it consistently, then again, you're leaving yourself open to some sticky situations.
Absolutely. One thing I found is some folks just email themselves a note, and then they place that emailed note they printed out or save a copy and put it in the employee's personnel file. Exactly to your point, Eric. I'm a small business owner myself, and I don't have time to document every small little thing. So that's what I do. I email myself.
Yeah, good idea.
I want to go through and talk about kind of 4 basic situations where an employee is separated from employment. So involuntary termination for cause, this is where you're terminating somebody generally for a policy violation or a conduct issue. A layoff or position elimination. And here, guys, this is where I'm talking about in terms of layoff, not a mass layoff, but essentially where you're laying off one employee or you're eliminating one employee's position. A resignation, a voluntary resignation by an employee. And then finally, I want to talk a little bit about the concept of job abandonment. And that often comes up, and lately I've gotten a lot of questions on job abandonment as it relates to an employee's ability to file for unemployment benefits in North Carolina. So we'll talk a little bit about that as well. Eric, if you'll move us to the first slide here. So involuntary termination for cause. This particular scenario is one where our documentation as employers is very important. Once you make a termination decision, at that instant, the employee's right to file a claim is triggered. So I'm not saying that all employees are going to file a claim, but if you have an employee that potentially might file some claim, the moment that you terminate is the trigger for their legal right to file that claim. So you need to make sure that you have all of your documentation in place prior to that termination decision. So one key fact is before you make a termination decision or actually have that conversation with the employee, go back through and look at your disciplinary documents that you've been saving in the employee's personnel file. Perhaps talk to any other members of management that may have documentation or emails relating to performance or conduct issues with that employee, and go ahead and clean up that record before you make your termination decision, so that worst case, if a claim is filed, you have all your ducks in a row. So a couple things to just ask yourself. before you, again, make that termination decision and communicate that to the employee, my advice is always figure out if there are any potential claims that you need to be aware of. Not that it will change your decision to terminate, but it might make that kind of open your eyes to how you want to communicate that decision or communicate that termination. And we'll get to this a little bit later on, but whether or not you may want to offer severance in a particular matter. So a couple things, some are pretty obvious here. Has that employee ever threatened to file a claim or make a legal claim? Have they made a previous legal claim against you? And this, you may want to speak to some of the other members of management and ask if they've heard any rumblings from that particular employee. And the second kind of question here with multiple parts is, does the employee fall into a protected class? Now, typically when we think of a protected class, we think of those categories that are listed in or under the federal law, Title VII of the Civil Rights Act. Things like race, ethnicity, sex, religion, and then, of course, under the Americans with Disabilities Act, disabilities, and then under the Age Discrimination in Employment Act, age over 40. North Carolina law has its own protections, but they basically track those the federal law. The one thing that often as small employers that we need to really focus on is retaliation claims. And we talked about the Retaliation and Employment Discrimination Act in our previous webinar. And Eric, remind me, that was the last webinar, part 2?
Yes, that's exactly right. Yeah,
and
I'll put a link
Eric,
up here. Yep.
Perfect. So if you guys want to hear a little bit more about RETA, Eric will post a link to the recording of the previous webinar. But just as a broad kind of quick summary, employees in North Carolina, this is a North Carolina statute, so employees in North Carolina have additional retaliation rights under the state statute. So if an employee, and let me back up, there are several different categories that give employees rights, but I'm just going to talk about a few that would apply in an office-related setting. So generally speaking, if an employee has recently filed a workers' comp claim and we terminate their, fairly soon thereafter, and when I say fairly soon, I mean about 6 months, then it gives the employee the ability to file a retaliation claim based on their workers' comp claim. Same concept applies to an employee who may communicate some sort of safety concern. That doesn't have to be a formal complaint to OSHA or to your OSHA safety officer. It could simply be an employee making a comment to notify a member of management about a safety concern. In an office setting, that could be as simple as there's a leak in a particular room in the office building where they work, and it's creating a smell, a mold smell. Well, that could be potentially an air safety or air quality safety concern. And then the third protection is for similar scenario is for employees who may have made some sort of complaint about their wages. This is not, when I say complaint about their wages, guys, I don't mean employees who think they need to be paid more. What I mean is, have to do with complaints about whether or not they're being paid correctly. So if an employee makes a complaint, and again, this doesn't have to be anything formal, to a member of management about how their wages are calculated, whether they're entitled to overtime, whether they're misclassified as an exempt employee and aren't earning overtime, and they feel they should be. So if an employee makes that type of complaint about their wages, then they fall into this additional protected status. So if we terminate, again, within a short period of time, and typically that's around 6 months, then it gives the employee the opportunity to file a retaliation claim based on their wage complaint. So when we analyze, or when we go through and analyze prior claims, let's not forget about those additional RETA retaliation protected classes. All right, so we're going to talk a little bit about employee communication before we go into the other area, separation scenarios. And the reason is that typically in that involuntary termination, it's the most difficult employee communication. So just a few quick points. One, when you have that conversation, be very brief. It doesn't need to be more than a 10-minute conversation. When you're communicating their termination, again, you don't have to provide a reason, but often in that scenario, it helps appease the employee if you provide the business reason, and if you've been documenting it, they should be aware of that issue. So if it's an attendance issue, you know, they should be aware that because you have communicated to them on multiple times, even if it's not formally, but you've communicated to them your concern about their attendance. The second bullet here, and many of you have heard this, I'm sure, before, whenever you're having a difficult conversation with an employee, it's always best to have a member of management there as a witness. And when you document that final termination conversation, which would be your final piece of paper that would likely go in your personnel file, you want to also have that management witness sign off that you had this conversation with the employee. Before you walk into that meeting to terminate an employee, and Eric will talk a little bit more about this, you want to make sure that you have gone ahead and deactivated all of their access to any company technology or resources. And the reason is you don't want to upset an employee in that conversation and then allow them to go back to their office and potentially obtain information that you don't want them to have at that point. Fourth bullet, as many of you know, you want to collect, if you can, all company property that the employee has in their possession. Now, you may need to coordinate if the employee has items at home. Often it's a laptop or documentation on a project, perhaps. If they've got any property or equipment at home, then you want to coordinate an opportunity for them to bring that into the office or mail that back into the office. And then, as I said before, you do want to document this termination discussion and document their last day worked, and that should be, again, maintained in the employee's personnel file.
All right, so I'll just jump in here real quickly before turning it back over to Mimi and talk about technology and user terminations. And these are some of the things that we go through with customers that you need to kind of think about when you're kind of in the middle of this. So number one, network access. Oftentimes if you change a network password, especially like on a Windows network, it's not going to terminate any active sessions they have. So if you're going to change their password, make sure that your IT company goes in there and disconnects their session, or just shutting down the workstation will do the same thing. So either way, but if you just change their password, their workstation's up, then they can still have access to your company data. Third-party sites, a lot of us, in fact, probably all of us, have some type of cloud technology that we're using, and it has separate logins that don't sync with our Active Directory or corporate network logins. So making sure that you're removing access on those third-party sites, keep a list of those things. And something that will help with that is a password management tool. So ideally, you have something like LastPass where all of the employee passwords are kept in there, and in many times, like the corporate versions, the employee doesn't even know what the password is to the third-party site, and you can go in the back and shut off their access to all of those sites. Third, cell phone access. Obviously, emails, if they have email clients set up on their cell phone, making sure that you can terminate that and testing that ahead of time. And that's something called mobile device management. So ideally, you can put a call into IT, and they can wipe the person's phone and disconnect all of the data there. So a lot of times, even several of the email clients that people have, new email won't come through, they can still have access to all the old email, and mobile device management will wipe that out for you. Fourth, VPN, extended authentication. So oftentimes when we first engage with customers, we'll see they have a VPN set up, and it's not connected to Active Directory. So in other words, there's a network login and there's a separate VPN login. And if you change or disable the network login, that has no effect on VPN unless you're using something called extended authentication. So be aware that even though you may wipe off all those things that internally change their password, disable their account, all that, they may still be able to get into the VPN if that is a separate authentication. And then lastly, password resets across the board, and this often gets overlooked. Even though you may be locking somebody out of your network, often is the case that they have shared a password or someone else has shared a password with them on how to get to certain sites or certain access. Just in the normal course of business, just based on expediency. So it's always best practice to do a password reset across the board for all employees, even the ones that are staying, to ensure that you have a good reset on that termination.
Guys, just as a recap, one thing, if you haven't already done it, one thing that simplifies the process is to come up with a checklist. So if you're managing that termination process, use Eric's bullet points and then maybe a few from my previous slide to put together your own checklist of all the items you need to think through and go through before you actually make that termination decision and communicate that to the employee. All right, so next scenario is a layoff or position elimination. And again, we're just talking about kind of one particular employee. And generally, if it's possible, it's always better for the employer to have either a position elimination or to have the employee voluntarily resign. From a legal defensive stance, it's much easier to defend a claim where one of those is the reason for separation as opposed to an involuntary termination. So before you make a decision, especially about a position elimination, often employers will just tell an employee that we're laying you off or eliminating your position, and they haven't actually gone through the basic steps to establish a position elimination. So a couple things we want to do is figure out what is the business reason that we are eliminating the position. And often it can come down to a budgetary reason. Or maybe you're changing your entire management structure or employment structure, or it could simply be a change in the service or product lines that you offer as your business. So you want to go ahead and come up with or really document the business reason for that position elimination, and it could be as simple as again, an email between management on the reason that it doesn't make sense to incur the cost of the salary and expenses in connection with that position. And the other piece here is, again, just like we did in the involuntary termination, you want to go through and make sure that there aren't any potential legal claims that you're not aware of. So go through that same analysis to determine if there is a threat of a potential claim. And often, kind of last comment here, when there's a position elimination or a layoff, this is a termination without cause. And so often it's common, and some employees expect some offer of severance pay. So determine ahead of time if you want to provide some sort of severance. Or at least be prepared to respond to questions from an employee if severance is inquired about, simply because it is a common thing to offer with this sort of termination. And regardless of the fact that you have terminated or terminating this person technically without cause, in all scenarios where you're going to be providing a severance pay, and we'll talk about this in a little bit more detail later, but in all scenarios, regardless of whether it's for cause or without cause, my advice would be for you as a business to have a template severance document. And that severance document would outline what you're providing to the employee, the benefit you're providing. Typically, that's a certain amount of pay over a period of time. And what you want to also have in that document, of course, is a standard release of claims. and we'll talk a little bit more about that later. But regardless of how you provide or when you provide that severance, my advice is you always use the same template form.
Mimi, I actually got a question. If we can go back here. So the question that comes in is this: collecting company property. What recourse does an employer have if an employee doesn't return property, like keys or a laptop?
Got it. The unfortunate thing is not much. And I hate to be the Debbie Downer, but we as employers our hands are a bit tied. So the primary questions I get are, can I withhold final pay until they bring my property back? And the answer there is no. In North Carolina, we're not allowed to. Yeah.
Self-confession. We've done that, so I'm assuming we can't do that anymore.
Right. So you're not allowed to withhold pay until property is returned. And the second question I often get is, can we deduct from final pay if they fail to return property? So things like a laptop, to your point, Eric, or, often it's a cell phone, that sort of thing. And the answer there really is no, unless you've done some work ahead of time. So if you have a voluntary authorization signed by that employee that gives you permission to deduct a particular amount, a predetermined value of that property from their final wages. So if you have that deduction authorization voluntarily signed by your employee, then you generally can make the deduction. There are a couple caveats to that, though, or limitations on that. If the employee is non-exempt, meaning that they are eligible for overtime, then that particular employee at all times has to at least earn minimum wage and overtime for all hours that they're working. So if that employee is not earning much more than minimum wage plus their overtime, we can't deduct very much from that final paycheck because we are limited and we can only deduct down to the value of their minimum wage and overtime that they have to be paid. The second caveat is for exempt employees. So those employees that fall under a federal and state exemption. And so part of that exemption, often one element of those exemptions, is that you pay a set salary every month, or every pay period, I should say, regardless of how many hours that employee works. So if we make a deduction for something like a property value, assuming we have that voluntary authorization, if we make that deduction from the standard salary that we pay that employee, then we can actually impair the exemption. So my advice would be to generally not make deductions from an exempt individual's salary. A one-time exemption may not impair, or one-time deduction may not impair the exemption, but it opens the door for the employee to make that challenge. And if that employee happens to be one that likely has been working a lot of overtime, then it can trigger additional overtime payments. So the best advice I can give on the company property piece is when you hand an employee, when everybody's happy, and you've hired that employee, or everything's great, and you're all excited about onboarding that employee, and so you're handing them this fancy property, the new laptop, the new iPad, the new cell phone. At that point, have the employee fill out or sign your voluntary authorization, and that piece of paper will document the equipment that you're providing to them, will identify the value of that equipment, and the employee will sign a statement that says that they understand that if they fail to return it in good working order, that they're giving you the ability to make that deduction from wages. The other key piece is, to try to just keep on top and manage, make sure you know where that property is at all times. And that way it might make it easier. So if you are going to make a termination decision, and you know that employee maintains that laptop at home most of the time, figure out an opportunity to ask them to bring it into the office And so that hopefully when you actually have that conversation, the property is there on site and not sitting at home.
And
Great question.
one thing we've done, and your point is well taken, that we can't really withhold wages in exchange for property. But if you do something like, all right, I'm going to make your last check a live check, and I'll have it at the front desk when you stop by to pick it up, bring in your laptop and keys. Now, I guess legally they could come in and pick up their check and not bring anything with them, and there's nothing we can do. But you would think or hope at least that they would take that opportunity to have an exchange, if you will, of laptop for last paycheck.
Right. If you're going to do it that way, then I would just make sure that you document when that final pay is required to be paid. And so we're kind of jumping ahead a little bit, but final pay for any employee, regardless of how they're separated, we're required to pay that on the next regularly scheduled pay date after the termination date.
So you can't skip a paycheck. I mean, whatever their next pay date was or should have been, you still have to honor that.
Right. So generally speaking, so if you're gonna provide a hard copy check, and you're gonna leave it at the front desk for them to pick up in exchange for keys and equipment, you want to make sure that if they don't do that or come by before that next scheduled payday, that you make sure that you put that check in the mail, even if they haven't provided the property.
Got it.
You don't want to miss that deadline. The other piece there is, generally speaking, in North Carolina, when you terminate someone and you're providing that final pay, you are supposed to provide final pay in the same manner that you generally pay your employees. So if you normally pay by direct deposit, then the final check would go by direct deposit. If you normally pay by live check and everybody picks their check up at the office, then you pay by live check. The only exception to that, generally speaking, is that the employee can request that you mail them their final pay.
Got it.
All right, let's move to next slide. One more.
Yep, sorry.
That's okay. All right, so voluntary resignation. Just a couple thoughts here. Sometimes when employees voluntarily resign, sometimes they subsequently change their mind. So what we want to do, again, as an employer, one of your to put you in the best legal defense position possible, we would prefer that the employee voluntarily resigns from their job. So if an employee resigns, my first comment here is make sure you get it in writing. And I don't care, it does not have to be a formal resignation letter. This could be as simple as they write it on a scrap note, piece of note paper or a napkin on your desk, and write on there, sign it and date it, that they've resigned effective immediately or effective on whatever date. But get it in writing. If they refuse to provide it in writing, then you document it. So you would put together essentially, and often you can use the same disciplinary form that you use when you counsel an employee, but you want to document what occurred. The employee came to you into your office and indicated verbally that they had resigned their employment immediately, and you as the manager sign and document that, and that becomes your documentation of their resignation that goes in their personnel file. So when an employee resigns, document, and get it in writing. And the second bullet really has to do with your notice provisions. So in North Carolina, and as we've talked about, generally under an at-will scenario, employees are not required to provide any notice before they resign. Now, a lot of employers will have a policy in place that will say one of two things. We request that you provide us with 2 weeks notice, or it might say we require that you provide us with 2 weeks notice. Now, if you have a policy in your handbook that says that you require 2 weeks notice and you follow that policy, then technically the employee could argue that you have converted their at-will employment to a 2-week employment term. So you've converted them from at-will to a contract employee with a 2-week term employment. So if you have a provision that requires notice, and if you do not want the employee to work during that notice period and you want to send them home, my advice would be that you pay out the notice period. If you have a policy that says that we request that you provide 2 weeks notice, then you have not potentially converted that at-will employment. And so if you want the employee to work that notice period, that's fine. If you choose not to, that's fine as well. Now, one quick thing here. If you request notice and you tell the employee that you don't need them to work that 2 week period and you send them home, you want to make sure that you haven't actually changed their voluntary resignation to a termination. So if you don't want them to work that notice period, then you can send them home and you don't have to allow them to come into the office, but you want to either put them on an unpaid leave of absence and make sure that you indicate that you have accepted their resignation, or you want to allow them to use any PTO that they have to pay them out through that notice period, perhaps. But we want to make sure our documentation doesn't indicate that we've terminated or converted them from a voluntary resignation to a termination scenario. The other piece where your notice can often play a role, your notice requirements, is some employers will indicate that if an employee provides the requested notice, that in those scenarios there's some sort of benefit. For example, if you have accrued PTO or accrued vacation, a lot of employers will say, if you provide us with 2 weeks notice, we request it, and if you provide that and work out your 2 week notice period, that we will pay out any accrued PTO upon, after your last day. And then in all other scenarios, you don't pay out your accrued PTO or vacation. So it could impact potential benefits depending on the notice requirement in your policy. The other piece is you want to clarify what the employee's last day worked is, because last day worked, as most of you know, can impact any insurance benefits that are provided. And then as well as it can impact when that employee might be eligible for unemployment benefits. So just clearly document or look at the notice requirements in your own policies and how that might impact final pay, benefits, and last day worked.
Mimi, 2 questions came in. Yeah. Can you withhold deductions from the last pay? Let's say the employee leaves mid-month and the office is only withheld 1/2 of their insurance contributions. Can we withhold the second half of those insurance contributions on their last check?
So generally the answer is yes. So any deductions that the employee has voluntarily signed, and so insurance benefit enrollment documents would be that voluntary authorization. So anything that the employee owes you as a reimbursement can be deducted based on those voluntary authorization forms.
Got it. And another question is, as a policy, we always handwrite a terminated employee's final paycheck while we direct deposit all other paychecks. Is this okay?
My advice, generally, it's okay. My advice would be that you continue with your direct deposit for that final pay. There's no reason to convert. There's no legal reason to convert from direct deposit to a live check. And often where you see that occur is where employers believe that they have to provide final pay as a live check on that termination date. And in North Carolina, you're not required to do that. So if your direct deposit is already set up to go, there's no reason to change that process. Technically, under North Carolina statute, we are supposed to, as employers, use the same format to pay that final pay as we've used previously. And the only exception to that under the statute really is if the employee requests that you provide them a live check and mail it to them. So my advice would be that you, for that final pay, that you go ahead and follow your direct deposit process as opposed to converting it to a live check. All right, so let's talk a little bit about job abandonment. And this comes up again generally when I get questions about unemployment benefits. So when I talk about job abandonment, everybody, I'm talking about an employee that basically doesn't call you and doesn't show up for work. And so you've heard this term, a no call, no show. So when I talk about a no call, no show, that is someone who understands that they need to come to work. They know what their schedule is. They understand that if they don't show up at work, that you are going to consider that as a quit. So if you don't have a policy, so most of you may have a general attendance policy, make sure you have some language in your policy. Everybody go back and audit your policy. Make sure you have very clear language in your policy that says if they fail to call in, and in accordance with your policy, most of you probably have a procedure about how they call in and when they have to call in. So if they fail to call in for either, 2 consecutive shifts or 2 consecutive days or 3 consecutive shifts, 3 consecutive days, there's no specific requirement on the time period. You all as employers can set that, whatever makes sense for the role or for your industry. But if the employee understands that if they don't show up, and your policy should state, if they fail to show up, no call, no show for 2 or 3 consecutive shifts or days, then you as the employer will consider them to have voluntarily abandoned their job. So the one key thing I want to clarify is this: nowhere in either your documentation of that situation or a letter that you might send to the employee or confirming the situation, or any documentation that you fill out if that employee files for unemployment benefits, nowhere in any of that documentation should we see the word termination or termination for job abandonment.
Because at that point, you've technically fired them, right?
Right. So if we want this to be the same as a voluntary resignation. So if someone fails to show up at work, we are assuming that they have voluntarily resigned from their job. So all of our documentation should indicate that the employee, their employment has ended based on job abandonment, and that you consider that a voluntary resignation. So a lot of situations where this occurs, the employer will send a letter or an email confirming that this is what's happened, to let the employee know that you have processed their separation as job abandonment. And so that's perfectly fine. Just make sure, again, you avoid the phrase termination for job abandonment. And here's where it becomes important. If that employee files for unemployment benefits, and most of you are probably familiar with the basic process, but one of the first documents that you receive as the employer asks you, was this a quit or a termination? And there are a few other options, but essentially what you want to put on that form is that the employee quit. And you want to indicate on that form that the employee failed to show up for work on these days or for these shifts and didn't call in, and so you process them as a separation, as a separation for job abandonment. So you want to attach a copy of your attendance policy that indicates that well-crafted policy that indicates if there are no call, no show, that it's job abandonment. And you want to provide your documentation of those days where they failed to show up. And again, that doesn't have to be anything formal. That could be just the manager keeping a tally of the employee not coming into work. So you want to provide in that initial unemployment benefits documentation, you want to provide not just the form that the Division of Employment Security provides, but you also want to provide your copy of your policy and your documentation of the employee failing to show up.
So a question came up, and it's very close to kind of a somewhat similar situation we had, and this came up as a thread in the North Carolina Medical Group Managers Association as well. So no call, no show, you're kind of putting the bow on it and tying that thing off from a legal standpoint. But what if you have some call, no show? And here's the question that came up from someone in the audience. You hire a new employee, and in the first 90 days, they become ill and miss 3 weeks. You quote unquote terminate, not because of the illness, but simply you just got to fill the position, right? And the employee can't give you a time they will return. What do you do in that situation? And I hear that a lot, where it's like, hey, I'm out. I don't have any PTO. I intend to come back, but I'm just not sure when. And as a small business, you just can't leave that hanging out there.
Right. So, couple points. And this often depends on how many employees the business has. So if you have 15 or more employees, then you're bound by the Americans with Disabilities Act. So if the employee has an illness,
15.
15,
Got it.
15, and that's under federal law and North Carolina law. So if you have 15 or more employees, then you are bound by the Americans with Disabilities Act, and then we have a complementary state law that tracks the ADA. So if that employee has an illness that could equate to a disability, then unpaid leave could be a reasonable accommodation. So that's one factor to keep in mind. Now let's assume in this scenario that the employee does not have an illness that could equate to a disability. So one quick point. So when you think of, just as a very broad general concept, an illness that could equate to a disability are things like diabetes, cancer, sometimes, mental disorders or conditions like depression. It could be something like migraine headaches, extreme migraine headaches. So there's a very broad concept of what type of illness could equate to a disability. But we could spend days talking about the ADA. But let's assume, for purposes of this question, that the employee's illness does not equate to a disability. Or let's assume that you fall under the 15 employee threshold. So if you have an employee in the first 90 days, and most of you probably have a 90-day probationary period, or I like to call them introductory periods, just sounds prettier and happier. But most of you have that sort of 90-day policy. Now, that is generally a good HR best practice, but the legal reason to have an introductory period in North Carolina and to have that introductory period to be approximately 90 days is that if you terminate an employee within the first 100 days of employment, because bless their heart, you've trained them, you've tried, but that employee just cannot perform the job. They're unable to perform the job. And part of that could be an attendance issue. They're unable to get to work. So if within that 100 days, they're unable to perform the job and you terminate, then for purposes of unemployment benefits, if the employee subsequently files, then if you as the last employer get tagged onto that particular filing, you can request that the charge, that their benefits not be charged to your account. So if the employee is granted benefits in that scenario, then you can ask the Division of Employment Security, it needs to be in writing, to make that grant of benefits, quote, non-charging to your account. So generally, if the employee is not disabled within that first 90 days and the employee cannot meet the basic requirements of the job, and attendance is usually for most positions a basic requirement and an essential function of the job, then you're not required as a small business owner to hold that job open. Now, if you're a larger company and you've got 50 or more employees, And if the employee's been with you for a significant period of time, over a year, then there may be other things to keep in mind. But for a new employee under 90 days that can't meet those essential functions, then you're not required to hold the job open.
All right, cool. Let's see here. Actually, one more question. So, and I think I know the answer to this one. Actually, I think I've heard enough. I've heard you speak enough that I think I know this. Our office is only 4 work days, so do we have to give them 2 days of no show, no call, or can we terminate after 1 day of no show, no call? And I'm guessing you're going to say it's up to the employer as long as it's documented ahead of time.
Absolutely. So if you just want to make, good job, Eric. If you want to, that's really up to the employer. So you just want to make sure that you craft your attendance policy to clearly indicate what what the requirements are, the call-in procedure, whether it's a 1 day or 1 shift, or a 2 day or a 2 shift. A couple things you could also clarify is how the employee has to call in. You know, a lot of folks, given our new technology, will send a text message to a manager. Well, if you want to make sure you clarify in your policy whether that's allowed. Can they send a text message? Can they send an email? Do they have to actually call and speak to someone on the phone? Can they leave a voicemail?
And I'm assuming to who also, because somebody
exactly.
Oh, I texted my coworker and let him know I wasn't going to be there. Well, that ain't good enough.
Exactly. So if there's a specific methodology that they need to follow, indicate that in your call-in procedure under your attendance policy, so that it's very clear what the employee has to do to notify you. You know, scheduled sick days scheduled days out, it's easier. You may have to have some flexibility with emergencies that pop up. So just sort of think through what makes sense given the way your business operates, what you need, the advance notice that you need in order to cover scheduling, make sure that patients or clients or customers get covered by another employee if someone can't be there. So just sort of think through practically what the steps are, and then it makes it a lot easier to discipline or terminate if they fail to meet those basic notice requirements or call-in requirements.
And one clarifying question on the 15 versus 50. So if you're under 15, I just want to clarify that you're not required to hold open a position.
Right. So the 15 employee piece applies to whether or not you as the employer are obligated to provide reasonable accommodations under the Americans with Disabilities Act and a complementary North Carolina statute as well. So if you are 15 employees or more, then if you have 15 employees or more, then if an individual, whether they've been with you 1 day or 2 years, if they are ill or sick, and that illness can equate to a disability, then unpaid leave or paid leave could be a reasonable accommodation that you as the employer may have to consider providing. If you do not have 15 or more employees, then you are not obligated to provide a reasonable accommodation, which means that you don't have to consider unpaid leave for a period of time.
Got it.
You can if you want to, but you're not required to consider that under the Americans with Disabilities Act. Great question. Thank you for that. Was that the only one, Eric? Was there another one?
I'm still yes, I think so. I'm still kind of sorting through them all, so I'm sorry.
Okay, that's okay. All right, so I think we've got a couple more slides, and I know we're bumping up against our time, so I'll try not to drag my feet. But if anyone has questions that we can't get to, Eric, please feel free to shoot those to me in an email. I'm happy to respond generally to the group via email if that's helpful. Okay, we touched on final pay a little bit, just in the great questions that you all and Eric's funny stories. So hopefully we'll be able to scoot through this. So final pay, like we said before, regardless regardless of whether the employee is involuntarily terminated, resigns, or what have you. In North Carolina, final pay has to be made on the next regularly scheduled pay day following the termination date, or the last day worked, okay? So what happens to accrued paid time off or vacation? If you have accrued paid time off or accrued vacation, and if the employee leaves, and at the time that they leave, they have an accrued balance, you are required to pay it out to them as part of the final wage payment, unless you have a written policy in place that the employee is aware of that states that you do not pay out accrued vacation or accrued PTO on termination or separation for any reason. So if you have a clearly written policy in place, then you are not required to pay it out. If your policy is vague on that point, or if you do not have a policy, then you are required to pay it out under North Carolina law. Sick days, accrued sick days, are treated differently in North Carolina. So if you have separate vacation and sick time, then accrued sick time does not have to be paid out upon termination or separation, regardless of whether you have a written policy in place or not. In that scenario, only the accrued vacation would be impacted. Wage deductions, we could probably do an entire seminar on. Unless you have, generally speaking, guys, unless you have a voluntary authorization signed by your employee, whether that's for a benefit they've requested, like insurance, or whether that's for property deductions, like we've talked about, when you provided that lovely piece of property to that employee and you have a voluntary deduction form, unless you have that voluntary authorization in North Carolina, we really can't make, we as employers are really limited in terms of what deductions we can make. Now, there are a few exceptions here. If you have loaned an employee money, so if you have, let's hypothetically say you've advanced wages to that employee and you have that documented as a loan, then the value of that loan can be deducted from final wages. But we need to have the loan in writing and signed by both employees. And that wage deduction for a loan doesn't include any amount that you might be charging as interest on that loan payment. Another exception for wage deductions has to do with if you realize that you have improperly overpaid and made a true error and overpaid the employee wages previously, and you need to recoup some of that overpayment from the employee, and it's truly an error and a mistake on your part, then we can make that deduction. I get a lot of questions about advanced PTO or advanced vacation. And Eric, I think you and I have gone back and forth on this issue too. But a lot of employers will essentially allow employees to go into the hole and use PTO or use vacation days they haven't yet earned. So this is a little bit of an anomaly under North Carolina law and federal law. So my advice would be, in that scenario, if you are going to allow an employee to go into the negative, or you're going to, in other words, advance them paid vacation or PTO that they have not yet earned, at the point when you give that approval, have the employee sign a voluntary authorization form that says that you have advanced them X amount of PTO. And if they fail to earn that back under your current policy, your PTO accrual policy, if they fail to earn that back, then they're authorizing you to deduct the value that you're going to put in on your form of the PTO that they have not earned. So now we've clarified and we have that voluntary deduction form signed.
And I'm guessing, I think we talked about this, the time to do that is not when the separation event has occurred, but when they request the PTO, before you approve it, say, okay,
Exactly.
Great, we're going to let you take this day off. We know you're going in the hole. If you don't earn it back, you're authorizing us to take out of your last paycheck.
Absolutely. And you want to put on that form the value of the PTO if they don't earn it. Absolutely. Once you've had to involuntarily terminate them, they're probably not going to want to voluntarily sign anything you ask them to deduct from wages.
Yeah, funny how that happens.
At the time, yes. So at the time that everybody's happy and you're granting that wonderful benefit to them, that's when you have them sign the form. All right. So we've kind of talked about the next question quite a bit. Final wages. Submitted direct deposit or live check. Most employers in North Carolina are pay employees by direct deposit. Actually, in North Carolina, you can require direct deposit. That varies state by state. But here in North Carolina, we can actually require that employees be paid by direct deposit. If you normally pay by direct deposit, your final wages need to be paid by direct deposit. Employees can request a live check. And we have to mail that live check to them. So maybe as part of your exit interview or part of your termination discussion, you confirm their correct mailing address if that's the case. And last little bullet here, final commissions or variable comp. So for those of you that also pay employees on commission or have some sort of variable comp program, final wages, if at the time that you terminate, you can calculate the final commissions or variable comp owed, then you're required to pay that final commission or variable comp with their final wages. If you cannot calculate final commissions or variable comp, let's say for a certain period of time, then once those commissions are able to be calculated, then you have to pay those commissions within the next regularly scheduled pay date after you can calculate the commission owed. Now, one quick thing. How employees earn commission or earn variable compensation, what they can forfeit if they quit or if they're terminated, all of that depends on the written documents that you have employees sign about commissions and variable comp. So if you guys have that sort of arrangement, my suggestion would be you want to make sure that the commission structure, not just how much commission they earn, 5% or 2%, but you want clarification on when they earn it and when it's paid and what happens if they are terminated or they resign. All of that needs to be in a written document with the employee. And in a similar fashion, the same applies to a variable comp program. So if you don't have it in writing, you want to make sure you get something in writing. And if you have it in writing, I would suggest that you have it reviewed by counsel. And Eric, I think we have one more slide.
We have 2 more slides. We're already over, but everybody's still here, so we're going to keep chugging along. So this is good stuff.
All right. Sorry, guys. Hate to go over. So severance pay, just real quick, a lot of folks think that severance pay is something that's legally required, and it's not. It's just you find that in certain scenarios, like we talked about with a layoff or position elimination, it's very common. So just a couple of thoughts. Like I mentioned before, no matter why you're providing severance, if you're going to provide that benefit, you as the company should get something of value in return for providing that benefit. And that something of value in return is a release of claims. So let's talk about generally what a release of claims in North Carolina can actually provide. And as a general statement, there are lots of claims that an employee by law cannot waive. So those are things like their right to recover or to apply for unemployment benefits, their right to recover any monies from a workers' comp injury. So they can't release those claims. The other one that's a bit confusing is that an employee cannot waive their right to file a discrimination complaint. In North Carolina, that complaint is filed with the Equal Employment Opportunity Commission. So a release cannot waive an employee's right to actually file the complaint. What they can release, however, is the right to recover from any type of discrimination or retaliation complaint. So if an employee waives their right to recover anything, then it very greatly reduces the likelihood that they will actually file that claim. The other piece is, if the employee has waived their right to recover from a claim, and if, worst case, I've never seen it happen in my career, but worst case, if the employee actually moves forward with filing a claim, more than likely, if they are, once they receive a notice of right to sue, it's going to be very difficult to find an attorney to take that case if the attorney is not going to be able to recover anything on the employee's behalf. Same applies to a scenario where the EEOC may have the option to proceed with a lawsuit on behalf of the employee. But if the employee has waived their right to recover, then the EEOC more than likely is not going to take that claim and argue it on their behalf. So a release can't necessarily waive an employee's right to file a complaint, but it can greatly reduce the likelihood that the employee will move forward with a complaint because they've waived their right to recover. So a couple other little points here. When should you consider severance? So generally, it's very common in a job abandonment or layoff or termination without cause scenario. But where you also want to consider severance is where you have a termination for cause, and perhaps the facts are a little sticky, the timing is bad. Maybe the employee has recently made complaints about safety issues, but you have documented issues, performance issues, but maybe just the timing or the facts are a little off, and so you want to just clean it up as best as possible. The other scenario is where you're terminating for cause and you need to. Practically, you're a small business and you need to terminate, but maybe you haven't done a very good job of documenting things. And so as sort of a safety net, you could consider offering severance in exchange for a release. How much severance should you provide? There's no real, I wish I could give you guys a clear idea of how much you should provide, but this is really on a case-by-case basis on how large your company is. And then it also comes down to how significant your legal risk is. So how important is it that you want this claim to be resolved on the front end, as opposed to having to go through the process of defending a claim or settling the claim, mediating the claim. And the third or fourth thing to consider, I guess, is that sometimes it's a matter of the individual employee that's involved. And you have to consider, based on what you know of this particular employee, what you think might entice them to sign a severance and release and what should be included in that severance. So, for example, it may not just be a payout of money. It could be coverage of health insurance for a period of time. That might entice a particular employee. It could be assistance with helping them find another job. So there are other sort of pieces to consider based on the individual employee's need.
What about conditionally waiving a non-compete? Would that be included?
Absolutely. That's an excellent point. So if you have had employees sign something like a non-compete or a non-solicitation, I wouldn't ever recommend waiving a non-solicitation, but waiving a non-compete is an excellent piece of value that you could put in a severance agreement that would allow the employee to quickly find another opportunity. And that is a significant piece of value that you can include in a severance package. Great point. Okay, so separation letters. Again, lately I've gotten a lot of questions about separation letters. These are not legally required, but often they're a good idea. And sometimes they're a good idea simply if you've had a scenario, let's say hypothetically an employee has resigned but has not provided you any documentation of the resignation, you can put together a separation letter that would essentially describe what occurred, and you would formally in your letter accept their resignation or confirm your acceptance in the letter to them. So sometimes if you want to clarify the reason for the separation, then it's a good idea to send a separation letter. This is also a good place. Let's say in Eric's early example, if you've had an employee with a significant attendance problem and you haven't documented that very well, you can use this separation letter to document all of those instances in writing. And now you're creating a current document. You're not trying to backdate any documentation, but you're creating a current document that clarifies all of those attendance issues. So from a legal perspective, it would be a helpful legal defense document. Other things to kind of put in that letter, of course, any final day of health benefits or insurance benefits, when they might receive a COBRA notice, or if you guys have less than 20 employees, maybe it's just a healthcare continuation notice from your insurance carrier. But giving them an indication of when benefits end and when to expect any follow-up documentation. If there is property outstanding that they have not returned and you've discussed with them when they need to return that, putting that in writing in your separation letter is a good idea. My advice would be always put a date of when they must return it. Don't just say it's immediately or as soon as possible. Put an actual date in the letter. And that way, if it's a significant piece of property and you do want to take some sort of legal action, you want to file a district court or small claims action, or even a criminal action for misappropriating your property. I know those are extreme examples, but if you want to give yourself the option to do that, you want a hard drop dead deadline of when they are required to bring that property back to you, and therefore when they have it unlawfully. And then last thing, and Eric brought this up briefly, but if there are additional ongoing obligations after they leave your employment. So if they have previously signed a non-compete or a non-solicitation or a confidentiality or an NDA, non-disclosure agreement, then those obligations continue in force after the employee leaves. And sometimes there's confusion with employees about what continues to apply to them. So if they have signed that sort of document, we want to outline those obligations in our separation letter, clarify the time period that those obligations continue, during which those obligations continue. And in some scenarios, if we haven't already provided a copy of those documents, my advice would be let's attach a copy with our separation letter, so that the employee understands what their obligation is going forward. So those are kind of the key components of what, from a legal perspective, I would like to see in a separation letter. Is that it, Eric, or do we have more? I think that's it.
That is it, I believe.
Okay. Sorry, guys. I did not mean to keep you over so long.
No, it's all great information. A lot of good questions here. I'm just scanning back through to make certain that I've got them all answered, and I believe that I do. So, again, Mimi, thank you so much. This has been so helpful for obviously for me to understand from a selfish standpoint, but also for all of our participants to understand what their obligations and risks are to hopefully get their game in order so they don't have to face those sticky situations. So this is Mimi's contact information. You can email her directly, or you can email me and I can shoot her contact information to you. Anything we can do to help. And again, Mimi, thank you so much for your time.
My pleasure. Enjoyed it. Thanks, everybody. If anybody's got follow-up questions, please don't hesitate to let me know. I'm happy to shoot a quick response.
Thanks again, Mimi.